Can someone hear me? Oh, thank you. No, I was answering the question to say I'm eating biltong, but excuse me. Let's just give it 2 or 3 minutes, then we can hit the road. Yes, yes. A lovely evening. You can share the life, you can share it, but I don't wish to be long. Ne? Thank you, Lady TK. I don't wish to be long. I just want to deal with one topic. Because if I deal with it doing a video, it's going to be longer. So I'll try to see. Hi, fruity. Okay, I think we can get into it. Let's begin and welcome everyone, and thank you for joining. Yes, if I lose you, please let me know by just typing a message here. Good morning. Sorry. Why am I saying good morning? Good evening. Good evening. Good evening. Good evening. Okay. Excuse me. In the morning, I think I was okay, thank you. Can you mute please who is There. Okay. No, who has the mic on? Please mute. Okay, thank you. Please mute. Thank you very much. Now, someone was asking the topic. No, the topic is about protected disclosure. That's Mashale's. Yes, thank you. See, someone sent me. Look, I'm not a Facebook person. I go there and there, so I tend to miss a lot of what people are saying on Facebook. So then a friend sent me a message from Patricia Morgan Mashale. I think she was responding to one of my videos where I was talking about the presentation that was made by SAPS management to the portfolio committee, because the portfolio committee asked them to answer to the allegations by Patricia regarding also her employment. So then from there, I was giving a feedback as to what happened to her case. And then she responded from that. But I want to get into that post she made. But before, I think I need to read. Excuse me. So she took one of the videos and then wrote something on Facebook. I'm going to read, and some of you might have seen it. And she wrote, before I read, I think I need to make it clear up front to say, look, I do not fight with anyone. I'm just putting things out in the public, assisting the public to make an informed decision, having both sides. Not sure if I will be able, but you can go to her Facebook. See if I try to share it here. It's fine. I'm trying to see how do I. No, it's fine. But let me read it so that. Fruity, out of order. You're going to harass me now on the community health workers. I can't talk about any other thing. That's harassment. Whatever I say something, you pushing me to that. It's not okay. So this Facebook post says, it seems that my matter being discussed in Parliament, and I just wanted to set the record straight once again. That's what she said. After I was charged for misconduct following my protected disclosures to the former National Commissioner, General Ketla Sithole, I immediately made an application in terms of Section 188A, subsection 11 of the Labour Relations Act at the Security Sector Bargaining Council. I was charged under Rule 9 in April 2021, and I submitted my application to the Bargaining Council in May 2021. I communicated with Pomashiane at the Bargaining Council and submitted my motivation to him to be protected under the Protected Disclosures Act and provided him with my motivation. It continues. Unfortunately, the Bargaining Council dismissed my application, citing that I did not provide adequate reasons to be protected under the Protected Disclosures Act. After the dismissal of my application, I approached the Human Rights Commission, and I wanted to listen. And they declared that my disclosures qualified as a protected disclosures and that any retaliation against me was unlawful and amounted to criminal conduct. It seems like more misinformation has been shared about me in Parliament. Fortunately, I always keep my receipts. And then she says, John Clark can confirm this information because he was part of the team who assisted me with the application to the Bargaining Council. Everyone is talking about me, but no one is approaching me to get the correct information. And as I said, when I was doing the video, I was communicating the version of, don't laugh, Nokwanda, the version of the SAPS. Because remember, the SAPS has been made this bad organization for years that is corrupt until Lieutenant General Mkhwanazi exposed all that. So, according to the SAPS, her disciplinary case, they said it went, or when she was charged for misconduct, because remember what I said she applied for a sick leave. That's what SAPS says. But then on the same day she was on sick leave, she was seen at a march presenting a memorandum of demand. And there in that march, and basically that's what SAPS says, she insulted the senior management of the SAPS. And I said, look, if you are going to take a sick leave, you are basically saying you are unfit. That's what we are saying. And therefore the employer is not going to bother you. But the moment they see you fit and you do dance and attend the mall and attend things, they will charge you and dismiss you because that's dishonesty. Because the whole point of a sick leave is for you to rest and not to abuse. So that could be taken as an abuse of a sick leave. And that's what SAPS charged her for. But then she claimed that her being charged for dishonesty and an abuse of a sick leave is because she had made disclosures or she had exposed corruption. Now, I want to take you through the law, because in this case, I'm proud to say I'm one of the relevant people to talk about protected disclosure. Yes, I remember I was advising a friend who took a sick leave, and then later that evening, she was seen as an MC. Obviously, then they wanted to take her to task to say you can't be on sick leave and still be able to be the MC. But now, let's come back to the disclosure and the section 188 she's talking about. So I was still saying I'm one of the relevant people to talk about this topic. And I normally say to people, I do have a book chapter that I'm writing on the topic. That's number one. Number two, I have experience because myself, I went to court to battle this topic, and this is one of the areas I'm very proud of because I wrote my own court papers, and we went to court. That's all I can say on that. But the point is, I was following every letter of the law and which section to do. Now, here I'm going to mention in the end to say she was misled, which is extremely sad. Now, let's go back. I want to take you through because this also could serve as now who's okay. People irritate me. I'm trying to mute this person or even block. Because how do you get in and do your things? That's kind of a disrespect. So, yeah. Now, I want you to take you through because this could serve as also more of an advisory session for anyone who might want to go through this. So I'm taking you through the Protected Disclosure Act. Now, there I want you to be patient and follow me because I want to take you through definitions of that chapter. And I hope someone is also taking some little notes. So we have a Protected Disclosures Act. Now I'm dealing now here with the definitions. I want to take one or two definitions. The first one I want to take is a disclosure. Then the Act defines what's a disclosure. It means any disclosure of information regarding any conduct of an employer or employee or worker made by the employee or worker who has reason to believe that the information concerned shows or tends to show one or more of the following. Then it lists those: a criminal offense that's been committed, the person who was supposed to do an obligation, they fail to comply with that legal obligation, a miscarriage of justice is about to occur, that the health and safety of individuals is likely to be endangered, it falls under a disclosure, unfair discrimination based on PEPUA Act or PEPUA, and any other matter that relates to the above. That's how they define a disclosure. So if you expose corruption, if you expose criminal activities, if you expose the risk or even the environmental damage, that's a protected disclosure. Or that's a disclosure. Now we go again, I want another definition which talks about now the protected disclosure. Then it defines a protected disclosure means a disclosure made to a legal advisor, a disclosure made to an employer, a disclosure made to a member of cabinet, or a disclosure made to an executive council of a province. Mlauzi, Agnes, you are extremely out of order and you are too old for what you are doing. Yes, let me do that, Ndumiso. Okay. Oh. Okay. Okay. Okay, sorry for that. I should have done that earlier on, but it's fine. Let's proceed, man. I think I'm going to mute people now. As I was continuing, sorry. So the disclosure then would be made to a legal advisor, to an employer, to the MEC, to the member of cabinet, and to a body responsible for that function, such as e.g. a portfolio committee. You can make a disclosure to a portfolio committee. Now let's quickly go to, I want to rush, Section 3 of the protected disclosure says, no employee may be subjected to any occupational detriment by his or her employer on account or partly on account of having made a protected disclosure. Now, what's an occupational detriment? An occupational detriment, I think they also provide here for definition, because I want to give you definitions from the Act instead of me talking so that you have reference. An occupational detriment means an employee being subjected to a disciplinary action after making a disclosure, being dismissed or suspended or demoted or harassed or intimidated, or being transferred against your will, or being refused transfer or promotion, or being subjected to a term or condition of employment, or being refused reference. If you're asking a reference, they refuse reference. that would be an occupational detriment if those things happen to you after you made a protected disclosure. So now these things happen as a form of retaliation after your disclosure. That would be your it's a retaliation. It's a form of a retaliation. That's a protected disclosure. So no one should be made or should be exposed to a occupational detriment, being suspended or being disciplined. Now, there's a remedy still on, that would be now section 4 of the Act, which says any employee who has been subjected or is subject or may be subjected to an occupational detriment in breach of section 3 that we've highlighted may approach any court. Now, any court, that would be labor court, that would be the high court, may approach any court, including the labor court, for appropriate relief or pursue any other process allowed or prescribed by any law. Now let's come back to section 186 of the Labor Relations Act. Section 186 of the Labor Relations Act says if you are subjected to an occupational detriment, the ones that I've listed from the Disclosure Act, then that is defined as an unfair labor practice. That's an unfair labor practice. That's 186 subsection 2D. Yes, 186 2D. So it's an unfair labor practice. What is the solution then when you go through a protected disclosure? Sorry, when you go through an occupational detriment? Number one, that's an unfair labor practice. So what you do, you now protect your right to fair labor practice. That means one option, you approach the CCMA and open a case of unfair labor practice based on 186 2D, because now that's a contravention of the Protected Disclosure Act. So when you get to CCMA, then CCMA will have to hear your case. But this is what happens also, and which is what I did. When your case is at CCMA, and I'm hoping there are also shop strats, when your case then is at CCMA, then you can then, there at CCMA, obviously, you might receive a certificate of non-resolution. Then you take that certificate of non-resolution and approach the labor court on an urgent basis. So you are, yes sir, uncle. So you received the certificate of non-resolution. Then you approach the labor court on an urgent basis to interdict the hearing. So you are saying you are interdicting the hearing pending your case of unfair labor practice, because you have moved from conciliation. Now you can jump the arbitration at CCMA and jump to labor court to adjudication. I hope you get the terms. So the initial stage is conciliation. But then in this case of section 186 2D, you can go then to the labor court after conciliation, go to the labor court and go for so that's adjudication. Now you want the labor court to adjudicate your case of unfair labor practice in the form of occupational detriment. But that case will take a long time, right? In the interim, and this is the mistake some lawyers do or they make. And I remember reading a case which my own union messed up, lost the case. And I said, okay, this is what you were supposed to do. But now, here's the case. You approach a labor court for the interim interdict. So you want the labor court to give you an interim interdict, meaning you interdict the hearing pending the adjudication of the unfair labor practice. That the labor court will give you that interim interdict. Alternatively, now we are coming close to Patricia. Alternatively, if you don't go through the section 186 to D, you go the route of 188A and subsection 11. That's the Labor Relations Act, 188A and subsection 11. Now, that's an inquiry by an independent arbitrator. Now, what that means is instead of the employer chairing the hearing, you ask the CCMA to say, no, you must be the one now as an independent arbitrator, you must be the one to determine the conduct. So 188A11 does say that if an employee alleges in good faith that holding a disciplinary hearing contravenes the Protected Disclosure Act, that employee or the employer may require that an inquiry be conducted in terms of this section into the allegations by the employer, into the conduct or capacity of the employee. So what in summary says, then the commissioner at CCMA will listen and now says, no, the hearing can continue, there is no occupational detriment. Or the commissioner could say there is occupational detriment and therefore employer stop the hearing. That's what the commissioner can do. And that's an independent commissioner. Now, this is the route that Patricia followed. After being charged, she went through the route of section 188A, subsection 11. But section 188A, subsection 11 has its own requirements. It's not there for the taking. You don't just claim that there's a disclosure. Number one, the CCMA or the bargaining council must accept that they have the jurisdiction. Once they accept that there is a jurisdiction, they have the jurisdiction. Okay. Yes, they do have the jurisdiction. Now, they can then start the process. Instead of now the employer chairing the hearing, it's the commissioner who is chairing. So with the case of Patricia, she did the same. She followed that and says, no, SAPS cannot chair my hearing as it was an expedited hearing according to regulation 9 of the SAPS regulations. But then they have their own bargaining council. The bargaining council asked her to submit certain things, and she put those letters in her Facebook that If you want us to entertain this, you must provide A, B, C, D. They listed. Let me read them quickly. From the Safety, Security and Sectoral Bargaining Council says, the nature of the protected disclosure, the date on which the disclosure was made, I'm going to come back to this one, to whom was the protected disclosure made, whether the disclosure is made in terms of Section 6 or Section 9 of the Disclosure Act. The motivation must support that the holding of an inquiry contravenes the Protected Disclosure Act. That's what the council was asking. That's basically very fair, to be honest, because if indeed there's a disclosure that you have made, you can produce that disclosure. 2, you tell the date of the disclosure. That's not difficult. 3, you tell under which section, the ones I've read from the Act, under which section is the disclosure made? Did you make the disclosure to the employer? Which in this case, Patricia says she made it to Ketlasitol, and that's the disclosure to the employer now. She needed to produce that. The reason they are asking the date, the principle of the disclosure is that the disciplinary hearing must the disclosure must predate the hearing, meaning you should have made the disclosure before the date of the hearing. You can't make a disclosure as a form of a reaction. So hence they are asking for the date because they want to determine whether this is a disclosure or this is just a retaliation from her side. And later on, when they wrote back, where they said, we have screened your referral form and advised that the bargaining council is unable to process the above mentioned dispute due to the fact that upon perusal of the motivation and referral form, we have noted you have failed to provide the bargaining council with sufficient reasons that your referral for the protected disclosure dispute falls within the scope of Section 188A, subsection 1 of the Labor Relations Act. You have also made no indication that you have made a protected disclosure to anyone at any time. And therefore the council says, then we cannot accept your application because you failed to provide these to us. So basically, her application did not fall within the definition of a disclosure. And her dispute did not fall within the context of Section 188A, subsection 11. And therefore, it was dismissed in a sense that now the SAPS can proceed to discipline her. It was fair for the bargaining council. Now, I want to come back to her to say, but also, and I'm trying to be fair also to her, also SAPS was also supposed to be, no, but I'm blaming SAPS for nothing here because SAPS consented, because that's the key for Section 188A, that the employer and the employee must consent. They must agree to say, no, you can refer your dispute. But then at the referral form, she failed to prove that this is a disclosure. She failed to tell the bargaining council who did she make the disclosure to. But in the public, she says she made it to Ketlasitol. It would be nice to see the copy of her protected disclosure. It would be nice to see that so that the public can judge and say, indeed, the bargaining council was unfair to you. But we don't have that privilege to say, yes, you made a disclosure, but the council did not treat you well. But the council was very fair to say, give us the disclosure, tell us the date of the disclosure, tell us who did you make the disclosure to, and tell us why your disclosure falls within Section 188. And therefore, when she failed, they dismissed that. Now, she was with the union person, and this is where now I come in to say, too many people have been failed by union officials because union officials, most of the times, or most of them, they lack knowledge. And the lack of knowledge is not because of any other thing, but their failure to read and equip themselves. So she was failed by her union. Now, someone told me, and I haven't verified this, someone told me to say, Patricia was together with Advocate Defo at SAPS, and they were trying to form a new union, because I said in my video, it could be SAPU, South African Police Union, or it could be Pop Crew. Then the person says, no, I work at SAPS. She was a member of Pop Crew, and then she left, she resigned. Then she went to join Advocate Tefu to form a new union. So when she went to the hearing with a union rep, which we heard from the Madlanga Commission, they marched out. A bad advice from the union official to just march out of the hearing. Because you leave the chairperson with no option but to make a ruling based on the version of the employer. But that union, which allegedly they were belonging to, was not recognized by SAPS. So it was not a recognized union. So I cannot then blame SAPU, I cannot blame Pop Crew, but her union failed her because they were supposed to help her with the Section 188A so that she succeed in stopping, because basically Section 188 is a replacement of a hearing or of an internal hearing. It's a replacement. But if the employer, now I'm coming to everyone here, if the employer refuses to conduct a hearing based on Section 188 and your disclosure qualifies to be called a disclosure, again, you can quickly go to the labor court for an urgent interdict, interim interdict, to say, I've referred the matter for Section 188, but they are continuing with the internal hearing. Then the labor court will, especially if your disclosure is valid and you have referred your matter to a bargaining council or CCMA, then the labor court will interdict the employer and say, you must conduct a hearing based on Section 188. There are too many cases, or there's case law regarding that, where the employer has been interdicted and ordered to conduct a hearing based on Section 188. A typical example, now this is very nice, a typical example is Imogen Mashazi, and I'm sure everyone here knows. Imogen Mashazi, this year, let me check the date. This year, Imogen Mashazi with Linda Xasheka. Let me read the comments. Do you know Linda Xasheka? Anyone who knows Linda Xasheka? And I will see if you listen to the Madlanga Commission. Linda Xasheka was the HR director at Ekurhuleni. They were working together with Zolani Simayi, and their boss was Imogen Mashazi. Now, these union people, two shop stewards, Thank you, Bonnie. Two shop stewards from this union at the municipality, the secretary of the union and the president of the union, exposed some corruption around Gasheka, and they said she prefers, or when new employees come at the municipality, she only tells them about Sizwe medical aid, and she does not market the other medical aids that are available within the municipality. And then they claim that that could mean that she's getting some kickbacks. So they made those disclosures, and then Linda Gasheka suspended them. Now, by suspending them, they wrote to the municipality to say, please allow us. We refer the matter to the bargaining council within the context of Section 188. And the municipality rejected that request. Then they said the hearing is continuing. Then they approached the labor court. That's the union. The name of the union is Municipal Employees and Civil Servants Union. And those shop stewards would be Vukile Mlungwana and Kosana Gold. They approached the labor court on the 19th of September of this year. Was the Madlanga on by that time? Yes, it was on the 19th of September this year. And they were asking for an interim interdict to interdict the internal hearing pending the Section 188 hearing. And the court agreed with them and interdicted the municipality. Here, what they were claiming, these two shop stewards, on the 17th of March this year, they wrote a letter to one acting, I think by then Mashaz was suspended by Mayor Kagazi. So there was an acting municipal manager. Then they wrote a letter raising allegations about Linda Gasheka's bias marketing towards Sizwe medical scheme. And they said those new employees are not made aware that there are other options of medical aids. So they were making those allegations against Linda Gasheka, which she became angry and suspended them. Now, on a surface level, that's a retaliation from Linda Gasheka. So her suspending them was a retaliation. And this is what the council was asking Patricia to say, tell us the date so that we know that you made the disclosure before you were disciplined or you made the disclosure after. So in this case of Ekurhuleni, these two shop stewards, they received suspension letters 2 days after they wrote a letter to the manager, suspending them to say, you are therefore suspended. On their suspension, I think on the 24th of March, that's when they were suspended on the 24th of March, pending the disciplinary hearing. And they received letters for a disciplinary hearing. That's when they asked to say, no, look, we are asking for us to go to the bargaining council through through Section 188. Now, which might be interesting to you, some of their allegations, they were alleging that Mr. Behari, we know Behari, we've heard Behari during the Madlanga Commission, who's the HOD of Legal Services, that Mr. Behari is instructing only his friends. Whenever the municipality has a litigation, he only briefs his friends, meaning it's only one panel of, one law firm that he's giving the job, yet the municipality has a panel of attorneys. So they were accusing Mr. Pehari of that. And also, they were accusing the acting city manager. Mareko Rulene has too many things. They were accusing the acting city manager of unlawful appointment of the group CFO. That's why they were suspended. But then they went to the labor court and they won. Actually, they won the interim interdict, where the court was saying the municipality is interdicted from proceeding with the internal disciplinary hearing pending the finalization of Section 188A, subsection 11, at the bargaining council. That happened on the 29th of September, 30th of September. Yes, that's 30th of September this year. So that's what you can do through the Section 188. But the way and the manner Patricia went about it, she could not prove that indeed she had submitted or she had made a protected disclosure, because she couldn't produce the date. She couldn't produce the protected disclosure that she had made to Kehla Sithole. So we can say SAPS was well within their right to discipline her. But because she marched out of the hearing, and now Regulation 97B says if you do that, you march out of the hearing, they will wait for you for 10 days to come back and say, no, on this date I'm available. But in the case of Patricia, together with her union rep, she never came back after 10 days. Now that rule 97B says, if after 10 days you don't come back with a new date, then you will be dismissed and discharged by the operation of the law. That's what SAPS was explaining to Parliament, to say, actually, she was dismissed through the operation of the law of Regulation 97B of the disciplinary regulations at SAPS. That's the story with Patricia Mashale, and I need to close this. Maybe I'll allow some comments to say there is no such thing as once a whistleblower, always a whistleblower. There is no such thing. You become a whistleblower for that particular moment. And secondly, the courts, I've read too many court cases around this topic. The court says you must have a reasonable belief that what you are alleging is true. Then the court again says, but you cannot defame people under the disguise of a protected disclosure. And in August this year, the court where she was fighting with Sibiya, the High Court said, no, you don't. Okay. How did I do it earlier on? Wait a minute, Knuckles, are you gonna be the dropper? Yep. Okay. You don't fall or you don't belong to the Protected Disclosure Act because you are not employed by the SAPS. Because this act is meant for employees or workers not for any person. So the court dismissed her defense because she was defending her defaming Sibiya by saying, I'm a whistleblower, I'm a human rights defender. You know that language of Mary Has. But the High Court says, no, that's not how it works. You are not a whistleblower. Number two, being a whistleblower does not give you a license to come up with unsubstantiated allegations. It does not give you a platform to tweet on social media, to post on Facebook about people and defame them. So the High Court rejected. And I wanted to respond over the weekend, but I was busy listening to witnesses A and B the whole day. I wanted to respond. There was a journalist from Mail and Guardian. That journalist completely misinterpreted the judgment. So I wanted to clarify and says, no, you are wrong. There's no court that said Patricia has a right to be the whistleblower. There's nothing in that judgment that says that. I read it more than once. So the journalist was lying, actually, was misrepresenting the judgment. And it pleases Patricia then when she reads such articles that says she's a whistleblower. When the judge said, you are not a whistleblower, according to the Protected Disclosure Act, you are not. I hope that is as clear as mud, right? Now, let me pause and allow some few comments. Thank you. I'm not fighting with her. I'm just making the facts clear to say that disclosure at the bargaining council was rejected. And therefore, SAPS had every right to discipline. And if they find you guilty, to dismiss. Because you failed to prove that you have made a protected disclosure. You can make a disclosure, but if it's not protected, then you are not safe. But this whole thing, much as it was about Patricia, but it is about workers and employees who need to expose corruption at their workplaces. But for you to be safe, so that they don't come after you or after your job, you need to go this route of the protected disclosure. Get that? So you need to understand how to go about the protected disclosure. Earlier on, I explained that's section 186 2D, where you lodge. It's a pleasure, DDJ, where you lodge an unfair labor practice. We allow for comments. Thank you. Sitembiso.
Emhlekazi kunjani?
Ndiyaphila tata khona kunjani?
Ikhona. Ya ndisakumamele ndisaconnect idots ihlo kudala ndithe chu nawe.
Amen.
Yebhuti.
Amen. Yes sir.
Patricia. I think personally my view she is in denial. We understand that she cannot deal or come into terms with it dismissal yakhe. We understand?
Okay.
Yeah,
okay.
that is my personal view. Now, indlela achanela grievances zakhe. Okay, well then. Story ska Patricia, while she was still under USAP support, she had all the time, we understand, to channel all these things as ibhalayo now currently ku Facebook and all these things as Twitter and everything. Uyandiva bhuti? Now xa kwenzeka i-dismissal, uyanderstanda, yakhe ngendlela ye-conduct yakhe uPatricia. Now she wants to claim into okokubana uyi-whistleblower. Now mna personally bendizibuza iquestion ethi all along ebehlelela intoni angazithethi ezi zinto, because clearly ezi zinto azithethayo uPatricia uthetha izinto okanye azibonileyo while she was still under u-SAPS. Uyandiva bhuti wam?
Yes.
Uyandiva? But now there will be confusing ke bhuti kubantu abanga-understandiyo ke indaba ye-labor practice okanye i-labor law uba ihamba kanjani, okanye abantu abangakhange babe kwi-workspace of dealing with i-workers okanye bangakhange ba-encounter i-challenges of being a shop steward. Ndisitsho nje nam previously I did serve, you understand, ndikwenye i-department endingazuyibiza ngegama, uyabo, while I was still there. But now i-challenge yam wona Fruitman is wona bhuti wam, le disclaimer ayifakayo okanye this claim ayifakayo that she's a whistleblower, xa kuzawuthi ijaji and ijaji ikhupha i-order as per i-regulation, because that judge I don't think is stupid enough, we understand, to rule out into okokubana akayo whistleblower. Andanoba uyandifumana na bhuti.
Yes. I'm with you.
But mna ndine-question nje bhuti personally nje ethi lo sisi ebethulele ntoni all these years, chief? If uzothetha ezi zinto xa edismisiwe, udismiselwe ntoni? There is a misconduct, and not just a misconduct, it's a gross misconduct ayenzileyo. But as I'm saying, ndithi personally mna, when I'm reading all these things, yonke le drama ayenzayo, yonke le nto ayenzayo lo sisi lona, lo sisi is in denial. And akafuni uaccepta, chief, akafuni uaccepta that she lost umsebenzi wakhe. And to me, uyabona, looking at all these occurrences to the up until to the minister, chief, uyandiva, yonke lento uziyofika ku-minister, partly I'm having my suspicion that there is something ebeyibhenefita la sisi in a way, qha akafuni uzaninyana. We are not all stupid, chief.
Exactly.
And anoba ndifuna nje uveza loo nto, la sisi is in denial big time, chief, and akafuni uaccepta that I lost umsebenzi wami. There is something ayaziyo uba I am losing there. Why she's protecting uGeneral Khan, chief? She's defending, she's fighting i-battle ekude. Remember, lo mntu le bekwinto ze-administration, she was not like a official like kwi-force yamapolisa. She was not even a police, uyabo, but ubhizi zizinto ze-operations zamapolisa, of which ke ii-clerks ne-admin clerks and everything kwa-SAPS, chief, ziyakwazi uba ne-information yezinto ezithile when it comes to operations ngamanye amaxesha, especially when it comes to taking minutes and everything, uyana, babanayo i-access to that intelligence yalo operation, uyabo. But this one, uyabo, the question is one, why is she fighting i-fight ka-General Khan? Why is she interfering kwinto ye-generals? Laa mntu ebeyiphaphethe, chief, lwa, I'm telling you. Yabo, qha ifuna nje umuntu one-sharp mind, sharp eye, scrutinize everything and break down everything. Mna, but my question nawe wena Zolani, chief, uzuzibuza umbuzo, yabo. Dala ndikumamela I think for 5 days ngoku, ndimamele zonke ilantuza zakho, yabo. I-question enayo, chief, lo mntu was in service emapoliseni. If she wanted to claim uba uyi-whistleblower, ebethulele ntoni all these years before i-dismissal yakhe? If we can start
now
to
we are now certain that after or even before her dismissal,
yes,
she was not Look, I need to be sensitive with her because there could have been a time where she was spot on. But I think at some point, hence I keep saying, she was misled by her union and allegedly by Advocate Defo, because also Naye, he was dismissed. So before I allow official minister, and I want to repeat this thing which I almost forgot, where she said, after the bargaining council dismissed her application, she approached the Human Rights Commission, and the Human Rights Commission declared that her disclosure qualified to be protected disclosure, and that any retaliation was unlawful and it amounted to criminal conduct. Now, that's not how it works. That's not how it works. This is a labor-related matter which falls under the jurisdiction of the Labor Court.
Exactly.
Only the CCMA or the Bargaining Council and the Labor Court and the Labor Appeal Court or the High Court can declare that a disclosure is a protected disclosure under the Protected Disclosure Act, not a Human Rights Commission. Worst of it all, the Human Rights Commission has no powers to declare something at work as unlawful. That's the power of the courts to declare something unlawful. And if you add to that, they said it's a criminal conduct. It cannot be a criminal conduct. This is where now she's misleading her own friends. And I don't want to say she's trying to get sympathy, but this portion is completely wrong, and it will take those who are gullible to accept it and blame the SAPS. But there's no Human Rights Commission that can do that. When the Bargaining Council rejects your application, the least you can do is approach the Labor Court to review the decision of the Bargaining Council, because the rejection or the dismissal by the Bargaining Council is an administrative act which can be reviewed under the Labor Relations Act to say you are reviewing the decision of the Bargaining Council through the Labor Court, not through the Human Rights Commission. Hence, I'm saying she's completely misled, and the person who's been doing this to her did injustice. Because the other part is, if then the Bargaining Council rejects your application, then you must go back to the hearing, of which she did none of those. And I'm sensing Mary DeHaas here, because maybe there at the Human Rights Commission claimed that she's a human rights defender. Pella, that's her song, I'm a human rights defender. Even at the High Court, she said, I'm a human rights defender, I'm a whistleblower. Maybe that's the logic when she went to the Human Rights Commission. Yes, sir. Official Minister.
How are you, my brother?
I'm good, man. I can't complain.
I see you are doing a very great job by educating us here. This is an insightful platform, and we appreciate it.
No, thank you.
Yes, I think you have summarized it very well towards the end, which is the point. You've taken my point there with the human rights. I wanted to touch on that point to say, I'll give a silly example, but that is spot on. If you are a football club and you are aggrieved, instead of going to South African Football Association, you then go to South African Football Rugby Union. And then you then say, according to Rugby Union, that matter must be resolved in this way. They don't have jurisdiction within the Football Association. You must go to the right platform. So I think it's exactly that. And I think we are also maybe robbed of an opportunity. We don't have all the tools of trade to evaluate as well. We've got a letter that comes from what's that, the arbitration. We've got that letter. We don't have the response, because they have mentioned how many? I think it's 5 or 6 things that they have mentioned on that letter. And each and every point is very important, because whatever you say is going to be evaluated against that. For an example, on the first point, they wanted to know the nature of the protected disclosure. Why does it matter? Because not every complaint or grievance is protected, right? They wanted to know what is it so that they can evaluate. If you don't answer it in a way that it qualifies, then you're going to fail. The second point is about the date. When did it happen? Because you cannot raise it after, as you have said, you cannot raise it after the disciplinary hearing, because then your point is not going to hold water. And then they asked whether it was a Section 6 or Section 9 of a PDA. The disclosure only becomes protected if it is made to and authorized, I don't know whether I must say people or an
Yes.
institution. You cannot post about it on Facebook and then you come and say it was a protected disclosure. So they wanted to know, to whom have you made that disclosure, right? And then on the other one, they asked for supporting motivation to show that the inquiry contravenes PDA. And I think this is where this is the legal test to say they need to evaluate how exactly is the discipline connected to that disclosure. Because if they are not connected, then you cannot show that they are linked, so there is no relationship.
What they call causal link.
Correct.
Put this banana bag.
And then did the employer bring those charges because you blow the whistle? Is the inquiry seen as a punishment or to silence or to intimidate you as an employee? So those are a relevant question. On the last part, they were asking evidence that, because you must say they are related, right? That causal connection you are talking about. And on point number 5, which is E, they are saying, now that you have told us that they are connected, where is the evidence? Show us that there is that a connection between the disclosure and what you are going through. This is a core legal requirement, I think, in line with that Section 187, if I'm not mistaken, and Section 3 maybe of, I'm not sure if it's Section 3, but they obviously want that evidence. And I felt like she was baiting us, because we were given all of these other elements, but we didn't have the document that says this is how I've answered these questions. So we can't really evaluate. All what we see is a rejection. But yeah, thanks for clarifying it. I think
No, thanks, man. I know you also have listened to some of your inputs in one of these lives. It's sober, very sober contribution.
no, thanks, much appreciated, my brother. And you are doing a great job as well. We are we are following you when you connect those
No,
dots,
thanks.
and they connect. They are no longer dots now. I see a straight line there. I don't see dots anymore.
You
What
see,
I see is a straight line.
you know, I would have told a story about my life. I was thinking about it this morning to like, Yeah, if I can tell this story on people, they will be shocked. See, when they talk about what's this, the informants, and they talk about counterintelligence, I know all those, but maybe one day I'll write a book and say, no. You see that analysis that was done by Lieutenant General Kumalo, I think it was once done to me because one of my friends once complained to say, hey, when I think he dropped me somewhere. As he dropped me, as he's going back, there was a car following him. So it's like, after you, the car followed me all the way. And then I was like, no, relax. No, relax. Those are my people. Either they want to check who is around me, who is too close to me. Is that person safe or not? And when I go to the restaurants, there should be cameras around. So I was laughing to be like, no. The car was not following you, but the car was concerned that you dropped me somewhere. So they are interested in you. Who are you? Because their intention is to look after me. But when I think about that, I laughed. Like, so these are the
You
strange
must
things.
share
And
that
then
story one day.
one day I will. So I understand when they talk about counterintelligence. You remember that threat assessment report I was telling you about that was done on witnesses A and B. It's something similar to that because, like, no, they are assessing your lifestyle. They are assessing the people around you, how dangerous they are, what's the risk with you being around those people, your workplace, how risky is. All the places you go to, they check to say, is there a risk? And then they will come back to say, yeah, there is a high risk. Or they say, no, there's no risk. Because I also have a friend who was being followed. But the people who were following him, they also did not know that they are being followed themselves. Now that's counterintelligence. So you follow the people who follow this one. And then you are assessing to be like, oh, there's a car that always follow this one. We think there's a risk to that person. So yeah. So I was laughing. I'm like, some of these stories are entertaining. You wish to share with people, but yeah, at the same time, you also don't want to reveal certain things. Because in the end, that car that was following that car is a cop car. It belongs to SAPS, but it had tinted windows. Because he only got relief when he told me the following day to say, hey, brah, I was so scared. And I'm like, no, immediately after you dropped me, I got a call. No, let me not say. Yes, Mango, some of the things, they are just entertaining.
Mkhulu kunjani?
Yaphila kodwa kunjani?
Hello. Hi.
Yes, I
I
can hear
hope
you.
I'm audible. Yes. I ndithi mandingene before you go into intelligence and counterintelligence and what have you. Mkhulu, thanks for your elaborate, eloquent, and educational streams that you are pushing, and we're learning a lot.
Yes, sir.
Elamliti, I'm not going to go into particularly the case that you were talking about. Kodwa elamlithi thina as workers we have to be very, very knowledgeable when it comes to the law. before we take any action. Because if you look at most of what happens when workers complain, it would be done out of emotion in most of the time, and then later then want to play victim. You might as well be a victim ekuqaleni, but how you handled it will, in most cases, determine the outcome of how you started the whole thing. I suspect that's what happened with the case in Kuwait. Uthetha ngayo. Enye indaba, it's important that the workers must not stop joining e-union, but they must also have knowledge around what the union does or what the union doesn't do. For example, there are most of the unions, if not all of them, they have what we call retained lawyers or law firms.
Yes.
So yes, I'm coming to your point of shop stewards not being knowledgeable about certain issues when defending workers. So, workers have the right, whether it's an internal discipline or a CCMA matter and so forth. You can request, because policies of companies would always have a clause where they would ask, where it talks about you can have, an attorney representing you. So, generally workers don't understand that. You don't necessarily have to take a shop steward and servants in the act. You can always get an attorney from the union that you belong to represent you, because they have them as on retention. Now, these attorneys understand the law, most of them, and they will be, in that case, be able to assist. You are talking about the uh, Protected Disclosure Act, or Disclosure Protected Act, something like that. They would know how to handle these matters. Because even if you look at the Labor Relations Act, that act is very complex. Ifuna umuntu one-understanding njengoba uyichaza kakuhle section 188 kwenzeka ntoni nantoni. So it wants people who have an understanding of what is, or how to interpret this particular legislation in order to, do in this case. And then when you have that and you don't do things out of emotions, now you will be able to know. There's one instance where I saw on the media, one media house talking about, for example, General Mukwanas, when he made the allegations and said he can back them up with evidence
Why are
on the
you
6th
now
of
not
July.
dressed?
So they were saying General Mukwanas is a whistleblower. That's also a misnomer and a misunderstanding what a whistleblower is, or who a whistleblower can be. So also, even at work, you might have certain information of wrongdoing or corrupt acts that are happening. But if you are going to disclose those without an understanding of the law, you might not end up being a whistleblower. So those are the crux of the matters. My understanding of the topic of today. But even this whistleblower thing, it's a cumbersome matter, because if you don't understand how to go about it, then you end up either, being killed and so forth and so forth, because you end up either not talking to the wrong people, not knowing which authority to report to, and so forth. So it's very, very important that people understand. That's what the emphasis I'm putting on. The law, you don't need to be a lawyer, but if you understand how the law works and the policies of that particular company or department or whatever, SOE works, then you are in a good position to do certain things. Thina abantu abamnyama, we do a lot of things out of emotions. Understandably so, because ngamanye amaxesha izinto zivela usuke ukwazi, and maybe you are a good employee who wants to do the right thing, and then you are taken over by emotions. So, mkhulu wami, I just wanted to raise that point over without confining myself to politics and what is happening, because the matter that you are dealing with, it's surrounded by, I would suspect, quite a lot of dangerous people. So we wouldn't want to go much into, but to educate the public of how the law works, how to deal with it. Don't put emotions first. Relax, sleep over something, think about it, then take it forward. Now, if you don't do that, you're going to end up behaving like the lady, for example. Now, the information, if important or not important, we don't know. We're not there. It's in the public space and so forth. And it makes now, you go around running and looking for sympathy all over the place when probably you were the wrong one. And the law or whatever dismissals have shown that you were actually on the wrong side. Probably when she started, she wanted, it was a good thing or a right thing to do. But maybe the way she ended up doing it, it was wrong. Or being unable to produce certain information to say, because now you want to act as a whistleblower, to say, I disclosed this, kuzibani ba, usithole, ukhetha sithole, like you said, then, if you are unable to produce such information, it means that you were somewhere caught along the line. Now you want to act as a whistleblower. But I don't want to go too much deep into the nitty-gritties of this particular case in point. I just wanted to put my general, contribution across. Ndiyabulela, mkhulu.
Ako bhuti
No,
wam.
thanks a lot, Mango. Kitato, before you, there was Tabo, or you got, is it Tando? Yes, Tando Nako. You got in by mistake, or you left by mistake, but you can request again. Kitato, or Andres. Okay, let's allow Meti or Mati.
Ungathulele nje lo mntu. Oh,
Ombi.
uMethi. Umathi ingathi ndiyanoba nguye lo. Andiyazi ungathi someone is snoring there.
Okay, let's allow Andres. Not sure if Andres naye uyasiva. We also want ladies here. Where are the ladies?
Bafake bhuti abarequestayo.
bakhona bakho. Okay, guys, if there's no one who is interested, you can just join if you're interested, because in the end, we'll also have to bring this to an end, because the whole point one was to clarify the issue of the whistleblower and Patricia, and also I like what Mango said, also to equip you guys to say, yeah, you should know what to do, so that in the end you don't go back says, hey, I should have done it this way, and then now you are caught off guard. So this is also part of equipping, while it is also clarifying certain issues. Anyone who's interested before we wrap it up? So now you see why I couldn't do a video. It needed a live, this one. To say, no, let me do a live and explain it. I'm also, because I'm still new on this thing of live, I was talking to a friend of mine, like, one of the things I'm thinking of is put certain days to say, on this day, we are going to be talking about labor, and on this day, we're going to talk about social, economic, or political. Thank you, Nokwanda. Let's hear you say something. But the issue with those live for me is, unlike other guys here, I might not be consistent because I tend to get very, very busy. And I don't want to start something or promise something I am not going to be consistent with. Yes. So
Andiqondi uba ingayingxaki Zolani loo nto, as long wena the time that you will be available ngalo, you come with the issues or something that is you feel that we need to okanye you need to engage abantu kuyo, uyabo, but yona it's way much better than iividiyo zakho, you understand, whereas abantu
yes, yes.
you can actually interact ke ngoku kwi-live, we understand, you engage with people, because sometimes abantu they will just drop comments, we will see thezo comments later kweza video zakho, you understand, and nelaa xesha lincinci limited ngolona hlobo, there are things that you cannot articulate kakuhle okanye ungene kwipoint, funeka umane uyenza in sections and segments ngoko part 1 part 2 part 3, we understand, which it takes time. I think it's way better, but ngelo xesha available ngalo, just make a notification or drop a video ukuthi ngexesha elithilo you are available on live, we'll be discussing okanye kukhona this thing that you want to discuss, we understand, and
Yes.
hear i-views ne-opinions zabantu, uyabo.
Sure.
Kukhona into ethethwe nguMengo apha ke Zolani, uyazi, uthetha ngento yobana thina we tend to do things with emotions, uyabo. Whenever we've got grievances, we don't know the channels, but I think it's important in uyiveza lento ubana yazi ibalekile lento kuthiwa i-research. I-research, you check the channels, you check uqala ucheckshe i-case yakho uba istrongo kangakanani, then usearch uba ngaba zeziphi channels, uba ngaba into i-sensitive kangaka, ujonga i-sensitivity yaloo case yakho, uyabo. And then you research uba ngaba how to channel this, who to contact, and especially uconsulte abantu abazi-expert okanye aba-knowledgeable when it comes to labor laws, we understand, the labor relations, abawaziyo umthetho, abazazi i-acts, we understand, you sit down, you have a discussions, uyabo. And also one of the important things ebethethwa nguye uMengo is that indaba yoba knowledgeable kwe-shop steward is one of the key things. You understand? I think yenye into that I feel like you can touch on in the near future.
In one live, I said, one, think starting next year, I will be open to see where you have gatherings. Say you have 10 or 20 shop stewards in a certain province or in a certain region.
Yes.
There, they will be like, no, we want you to deal with a specific topic. Then I said, on that note, I'll be willing to say, no, I will come and offer some training. Because I'll tell you what, and this is the criticism I've been getting from my friends and comrades. I have been busy on a book, right?
Yeah.
But I'm more of a perfectionist. So I want the book to be the best. And then when they come to say, no, you are wasting our time, because you could start with a smaller Nyana book and then you can follow it later. So one of the things I'm considering now is a manual, where I write a manual. Like, say, for example, we're dealing with a protected disclosure. Then I come up with a manual on the exact practical things to do, as to say, this is the first step you do, this is the second step you do. And one of my close friends was like, that would be the easier thing to do, because he knows me. Once I say I'm going to write a book, I will want to exhaust a topic. I would want to, like, for example, if you wake me up midnight on the topic of protected disclosure, I would not hesitate. I'm like, okay, what is happening? Where are you? What is the story? Because I have too much literature on that one, or I've read a whole lot. And especially when I also, by the time I had my own case, it was easy to deal with it, because I'm dealing with something I'm very aware of it, or I'm knowledgeable about. So instead of me coming up with a book that could take some time, he's like, no, just give us manuals, where the shop steward could use that manual to say, oh, if we are dealing with unfair labor practice, what do we do? If we are dealing with employers who deduct from your salary, what do we do? So I'm like, yeah, it's something I need to do, and put up that simple manual. But of course, now that needs time, and that needs me to say, I need to sit down and really focus, because it's not a matter of needing knowledge, but it's a matter now of putting pen on paper, and then that's it. It's done. But also, while that one is still coming, the training will have to go on, Yona, because your training is to prepare PowerPoint presentation, and then you equip people while they are waiting for the manual. So those are options I am weighing. But then here's an issue. You guys come in and you talk about Madanga Commission. You're like, no, we need to know about witness A. And then that, of course, that will take its own time. But I'm enjoying it. I don't want to lie.
No, as I was saying, Zolani, it was just in my personal view. Uyabona, though nangona ke nam ndingene phakathi kulo live wakho, but I'm having serious glitches with my network today. I don't know what is happening. Uyabo. But I was just like saying my view kule nto yalo sisi, because I did ndiye ndazipha the past 2 days, ndiye ndazipha ixesha, like seriously. Namhlanje ndilele at 3 a.m. ekuseni ukusa ndazi I need to understand where does she come from. Uyabo. That's why ndayijonga le nto that, you know what, the past 16 years, 17 years working previously correctional services, ah, I did get a share of mine experiencing people who go through such a thing, but izikhona into
Okay.
psychological uyabo, izikhona into eziba-affecta psychologically abantu uyabo. So I was like, hayi kawuyeka but let me leave you in peace. I'll be
No,
in touch with
thanks,
you.
Dad.
Yeah.
Because I want to, before I close, I want to repeat what I said yesterday.
Mkhulu,
If there's one thing, okay.
ngicela nje to say last words nami ke ngiyophumula
Yes,
la.
sir.
There's one other thing that I've noticed. Earlier you were mentioning the Matlanga Commission, and perhaps you also deal with Salam on the same allegation. What I've noticed is that when I go on SABC on YouTube, there is this live chat where people comment when the commission is ongoing or the ad hoc committee is ongoing. And when you listening and reading through the comments, you would see or notice that South Africans, you know, there's quite a lot of lack of understanding of matters that are taking place, of systems of control, how we are controlled and indoctrinated without noticing and so forth. So my plea to you is, because I've been listening to I've been watching your videos as well, and I've noticed that your your comments or your analysis on what happened at the commission and at all is spot on. It's top tier. So if you can hold this line, particularly also on these matters that are going on the application, so it would also be wonderful. The more people get to understand about kwenzeka ntoni, not
Okay.
the face value stuff that we hear at the commission and the ad hoc committee. You have a tendency of digging deeper than what was there. So if you can deal with that as well, it would be lovely, because these platforms, there's about TikTok, and I'm fairly new on this, but I've realized that it actually reaches far and beyond, and more people get more information of exactly, and they are able to deduct uba kwenzeka ntoni kahle kahle, and not only what we have fed. Yeah, no, thanks. I'm gonna knock off.
No, thanks, Dad. Thanks. Anyone, the last one? Oh, I was saying my offer still stands for SAPS members. If you have friends or relatives who are, that they are under SAPS and they go through problems that are labor related, refer them, tell them, say, no, there's a guy who can help you because of what these guys have done. I mean, we talk about Mkwanas, we talk about Kumal. Because the truth is, they've done something big for the country. What they did is big for the country. So we also have to appreciate those honest members of the SAPS. Okay, guys, it's getting late. Let's meet again when we meet. And thank you for your attention, and thank you for those who commented, and thank you for everything. May you enjoy your sleep. Someone said they came late. Is it Bukamoso? he came late, but unfortunately, yeah, maybe next time. Maybe next time. Okay, guys. Yeah, hey, sorry you came late, but we're dealing with the issue of whistleblowing. Thank you very much for your attention. And I think from here we can close it. Right. Thank you, guys. Okay, I am closing now. Good night.